want some more?
May it please the Court, my name is Mark Aver with Aver & Smith in Gainesville, and I represent Barbara Cooke, the appellant and plaintiff below. I'd like to reserve 5 minutes of my time for rebuttal, please. We're here this morning for a de novo review of an order from the trial court granting the defendant summary judgment in a motor vehicle crash case in Alachua County. In granting summary judgment, the trial court essentially found as a matter of law and public policy that a second crash on the interstate when a negligent party causes traffic on the interstate to back up is not a foreseeable event. Some of the facts are important and need to be pointed out for the court's understanding of the two issues that I think bear on this appeal, that being foreseeability and whether reasonable people could differ on whether the second crash was foreseeable. Mr. Cooke was approaching the crash on Interstate 75 coming southbound towards a hill. The crash occurred on the south side of this hill on Interstate 75, and Mr. Cooke was approaching from the north side. Because of the crash, the Florida Highway Patrol dispatched an Alachua County Sheriff's deputy to the other side or the north side of the hill to warn southbound traffic. That deputy did that by turning on his emergency lights and putting out flares on the side of the road. There were no other vehicles with the Alachua County Sheriff's deputy, and by Deputy Hanson's testimony from where he was, he could not see the first crash or the vehicle slowing on the other side of the hill. At the time that Mr. Cooke was approaching Deputy Hanson, he was in the middle lane, as was Mr. Kindler. Mr. Kindler was driving the truck that Mr. Cooke struck in the second accident. Deputy Hanson says that the crash occurred about 20 yards past his patrol car. He heard it. He did not see it. He was leaning into his patrol car. Mr. Cooke would have no way of knowing anything about the first crash. The only thing that told anybody anything was the presence of the Alachua County Sheriff's deputy with the flares on the side of the road. Mr. Kindler was in a different position as he had a CB radio and was well aware of the crash and where it was as he had been listening to it shortly after leaving Lake City that morning. These two crashes occurred during the pre-dawn hours, approximately 1 hour apart. Reasonable people, a reasonable jury, could infer from those facts that Mr. Cooke was distracted by the deputy, looking at the deputy with flares on the side of the road, trying to determine why that deputy was there, whether there was a crash on the side of the road that he could not see. Unfortunately, as Mr. Cooke went southbound the interstate, he was overtaking Mr. Kindler at about 45, 55 miles per hour and struck the rear of Mr. Kindler's truck. There's no evidence in this record that Mr. Cooke was driving recklessly or in a grossly negligent manner as characterized by these defendants. In fact, it is important to point out that in reading the briefs of the defendants, particularly that of UPS, one could come away from reading the briefs believing that Mr. Cooke was in a position where he not only should have seen Mr. Kindler, he should have seen the first crash and the traffic backing up. That's not the case, and that is not the evidence. Our courts have addressed intervening cause on numerous occasions over the past quarter century. And it is clear that for an intervening cause to be an efficient intervening cause and not foreseeable, it has to be the type of event that is so extraordinary, so bizarre, so highly unusual that when a trial court looks at the harm and looks retrospectively back to the first negligent event and looks at the harm caused, the trial court has to come away and say, reasonable people cannot differ about this. This is such an extraordinary event, such a bizarre event that
based on the law of foreseeability of intervening cause, could the trial court at the summary judgment stage have taken into account the amount of time that had passed between the initial accident and your client's unfortunate accident?
It would appear from the record, Your Honor, that Judge Monaco did contemplate that to some degree. Although, in looking at the case law and the law of foreseeability, the appellate courts have not addressed a temporal aspect in their opinions. They really have not.
Well, surely there must be one, because foreseeability almost speaks to that implicitly.
And there may be, Your Honor. In thinking about this fact pattern, and this is a highly interesting fact pattern because it's unlike anything that appears in the appellate cases, if there had been a crash on a straight and level highway, and it was clear to the view of people oncoming that there was a lot of traffic in the pre-dawn hours when typically traffic is light, all kinds of warning signs, and after 30 minutes or so, or an hour, such as in this case, Mr. Cooke came upon those circumstances and without braking or doing anything, with all the warnings in front of him, ran into the back of Mr. Kindler. I think the temporal aspect would have a much higher degree of relevance in this analysis than it does in these circumstances. In these circumstances, it was almost a perfect storm, if you will. Mr. Cooke has no way to know if the first crashed. He's going up a hill. He sees a deputy with his emergency lights on and flares out. A reasonable jury could infer that Mr. Cooke was looking at that, trying to see, is there an accident on the side of the road? What's going on there? All the while, unknowingly, he's overtaking another vehicle that he's overtaken by a speed of 45 or 55 miles per hour. And Mr. Kindler says the crash happened right at the top of the hill. So a perfect storm, for you will, for Mr. Cooke, where the temporal aspect is not nearly as important as it might be in other circumstances. So with all due respect to Your Honor and Judge Monaco, I do not think the temporal aspect should have been an important part of the court's consideration. In looking at the case law, there are fact patterns that our courts have addressed over the years where the courts have found that the subsequent conduct was so highly extraordinary that the trial court and the appellate courts were willing to absolve the original tortfeasors of all liability. National Airlines v. Edwards is one, where an airplane was hijacked and the plaintiff made a claim against the airlines, not so much for the hijacking, but for the fact that she ate food in Cuba and apparently got very ill and claimed damage for that. Reasonable people would not differ on that fact pattern, that we would not see that harm occurring as a result of the hijacking. Psychological harm from the hijacking, perhaps. Food poisoning, no. The other case, the Supreme Court's case in England, is the other fact pattern that is important in this appeal, because it bears out another fact pattern where there was a finding of an efficient intervening cause, and the appellate courts said we agree. In England, some folks, because of a large puddle of water on the roadway, had their vehicle stalled. And while they were trying to get their car restarted, Mr. DeBose, who I'm sure today wishes he had a do-over, turned around and, for reasons that are not clear from the appellate decision, came flying back up the road to help them and rammed into the back of them and injured them. The trial court found that that was an intervening cause, and the appellate courts agreed. That is the type of factual scenario that reasonable people would look at, and we would all agree that in looking at the harm.
What you're suggesting about England, and I'll invite the other side to response, is that had the facts in England been a little different, and the car stalls in the puddle trying to cross the railroad tracks, and along comes DeBose half an hour later, and then rear ends the car, that the result in England would have been different.
It might have been different, Your Honor. It might have been different. And I should point out that UPS in their briefs argue that we are attempting to absolve Mr. Cooke of all liability. Nobody has made that argument on our behalf, and the plaintiffs do not argue that to the court today. We are not attempting. What we are arguing today is that the lower court erred by determining that all reasonable people would agree that this is an extraordinary fact pattern, and the original tortfeasors had no way to foresee that this was going to happen. Quite to the contrary, our human experience, as some appellate courts have addressed, tell us that when you act in a negligent manner and two large semi-tractor trailer trucks and an alleged phantom vehicle crash on the interstate and cargo is spread across the 3 lanes of the interstate, causing traffic to be blocked and slowed, that it is entirely foreseeable that subsequent crashes are going to occur. In fact, the Florida Highway Patrol bears that out, because they asked the Sheriff's Department to have a deputy go up and try to warn traffic coming down the roadway. Now, one could argue whether the deputy was effective in warning traffic coming southbound, but Mr. Cooke was in a position where he had no way of knowing that. I should talk about for just a minute what constitutes an intervening cause, an efficient intervening cause. And the Deese v. McKinnonville case by this court, decided in 2004, this court said, it is only when an intervening cause is completely independent of and not in any way set in motion by the tortfeasor's negligence that the intervening cause relieves a tortfeasor from liability. it would strain credulity for a party to argue in this case that it was entirely unforeseeable when you cause a crash on the interstate and cause traffic to back up, that subsequent crashes would not occur. The D.C. Court also said it is only when reasonable persons could not differ on the issue of foreseeability that a court may decide as a matter of law that a certain act or conduct constitutes an independent, efficient, intervening cause. So we are now in circumstances where the lower court was bound to accept all inferences in favor of the non-movement. That was the plaintiff below. I would submit to this court that reasonable persons could differ on this, and that it was not an issue that was appropriate for summary judgment. And at the trial court's level, the trial court should have denied summary judgment. Foreseeability in these circumstances was certainly an issue for the jury, and the trial court usurped the jury's function in this matter by granting summary judgment.
May it please the Court, my name is Carl Schwait from the Delgram Law Firm in Gainesville, and I'm here to represent the appellee, the defendant below, Nationwide Mutual Fire Insurance Company, who in this case stands in the shoes of the phantom vehicle. Justice Kogan stated in 1992, and pretty much was a treatise on foreseeability in the McCain case, that foreseeability is concerned with the specific, narrow, factual detail to the case, and not that broader zone of risk that we understand to be duty. In fact, he went on to state, even though he ruled that there was foreseeability or question of fact, in that case he went on to state that there is no foreseeability and thus no proximate cause when we have freakish and improbable chain of events. Now, with all due respect to the appellant...
What is the bizarre... I mean, anyone talks about a bizarre event... Florida Power Council. Let me posit this to you, and then you disagree with me. You got a wreck on the interstate where somebody sideswipes a parked truck because the phantom vehicle moves in the side. Blocks the interstate because the boxes don't. Another truck, in response to that, slows down, and he's rear-ended by the decedent. Where is the freakish event in this?
Actually, it's not just a freakish event, it's a freakish and improbable chain of events. And in fact, in the National Airlines case, they go on to say unusual combination of circumstances. Here's where it's at. And with all due respect to the appellant, there were several very crucial issues that are missing. And in fact, let me start with, it's improbable to begin with that after we accept, for purpose of summary judgment, that the phantom vehicle went to the side, that in taking evasive action, UPS would somehow find, improbably, that that other truck was on the side of the road, who just happened to stop because they have they thought they had a flat tire.
With respect, that's not the kind of improbability that the cases talk about. The kind of improbability the cases talk about is if the box falls off the UPS truck, there's some critical part for a factory in that box, and as a result of that box being run over, the factory down in Ocala doesn't get its part.
It's this fact that was missing in the appellant's argument. When the black box was taken out of the vehicle, it was learned that the deceased was going 70 miles per hour when he struck the truck. And not only that, 5 seconds before, 73 miles per hour.
In a 70 mile per hour zone.
Yes, I'm not saying, Your Honor, that that was anything in that moment wrong. What we're saying is...
But there was a police car with the lights flashing, showing there was a problem ahead. And another car had already slowed down to 25 miles an hour.
That's right.
And this also occurred an hour and a half after the accident.
Yes, and that is that circumstance and chain of events.
So even though the speed limit is 70 miles per hour, if you take the driver's course, if you've ever gotten a ticket and taken the driver's course, you know they say that 70 miles per hour in an unsafe zone, raining or when there's flashing lights, or that's no longer the speed limit, permissible speed limit.
There are 5 different factors to consider that the actions of the deceased was not only improbable, bizarre, highly unusual, extraordinary, all the words that the courts use, but reckless, and actually we would state to you was gross negligence. 1, the blue light on top of the car. 2, the flares that had been put up. 3, that Mr. Kindler himself had been driving 25 to 30 miles per hour for 5 minutes in the same lane as the deceased. 4, that Mr. Kindler himself had flashers on. And 5, you might remember the police officer stated that when he looked back, he could see cars on the top of the incline, as opposed to a hill, whatever we might call it, that their lights, when they passed him, were already starting to go on because they were stopping. Take any combination of those, 1 through 5, that's where the freakish nature and the improbability and the lack of reasonable foreseeability.
Comparative negligence of the decedent.
But there was no attempt to stop.
The Gibson case, except it's not the decedent in the Gibson case, it's another tortfeasor.
The reason the Gibson case is not applicable here is because of your former question, the time and scope. See, when that man stopped his car drunk in the middle of the case in the road in Gibson, there's the expectation that if you stop your car in the middle of the road somewhere right then, we're going to have that chain reaction. In fact, even the Deese case that was submitted to you by Mr. Avra is inapplicable because in the cases, they say something that no one's talked about, remote damages. And remote damages mean that there's a result over which the original tortfeasor has no control. You might remember in the Deese case, that's the case with the Hunt Club. Well, the Hunt Club had control. They had knowledge of what was going to occur. You see, Anglin is very applicable to our cases. And that's what the court said, and that's the Supreme Court in Anglin. It's reasonable that someone will come and provide assistance. Quote, it's not reasonably foreseeable that the person would act in a bizarre and reckless manner. That's what occurred in this particular case, Your Honor. In this case, the expectation is the cars are going to slow down.
Let me focus you, though. The bizarre, go back to my first question. The bizarre and unexpected behavior is the negligence, recklessness, whatever you want to call it, of the decedent.
That's correct. And the cases that we've cited, Judge Kahn, are myriad. For instance,
so what the intervening cause here is the contributory negligence of the decedent.
It's his gross negligence. That's correct. Because what
it remains to be, I mean, the judge didn't adjudicate that question.
No.
Certainly this wouldn't support punitive damages on behalf of the truck in front of him that he hit.
I'm using the word gross negligence and reckless negligence.
I want to be specific about this because all of us, I'm sure, have read a lot of intervening official cause cases. But the intervening cause here is, in fact, in your view, the negligence of the decedent, the ultimate plaintiff here.
That's correct. Because there is an expectation, as in Gibson, you're going to have an immediacy, as you talked about. You understand, this is not just a mile and a half. This accident occurred approximately 1 hour and 11 minutes. So it's the totality of the circumstances.
It was still slowed, wasn't it?
The vehicles were all slowing down. And, of course, a police officer was sent out, and that police officer went out and did those two things. And in that hour and 11 minutes, all the cars began to slow down. And that's the freakishness of the event, that the deceased, unfortunately, from the black box, we know it's a fact. No evasive action, no slowing down, had his cruise control on, perhaps is sleeping, I can't tell you, smashes in to the back of the car. Now, the Supreme Court in other cases have stated the following.
So we'd have to find that, go into the arena of tort law, we'd have to find that the decedent's recklessness or negligence and failure to slow down was not foreseeable, and we'd also have to find that that was the sole cause of his death, I think. Is that right? Or can we do one of those without the other?
No, you don't have to get to that. The issue, actually. What the issue you have to get to is whether, in fact, there was a lack of reasonable foreseeability as to the actions of that last person who happens to be this particular, the deceased. That's that lack of control, that when looking back to the harm and looking back at the beginning, would anyone have expected that an hour later someone would be driving with 4 or 5 indices of you better slow down, would slam into it. Not only just not slam his brakes and then find that he's skidding. In this case, the freakishness, the bizarreness, the extraordinary conduct is a total failure, in fact, to come to any stop. The Supreme Court made several statements, and I need to know that 5 minutes are reserved for...
You've got about a minute and a half left.
Yes, sir.
At the end of her time.
It's important to know that the Supreme Court, in sort of the questions you've asked me, that in fact negligent conduct, because it's negligent, does not set in motion a chain of events. It actually simply provides the occasion for someone else's negligence or gross negligence. And that's why the cases that we've cited in our briefs are so important. And just for a minute, in the Anglin case, the court said that there was bizarre and reckless behavior. Summary judgment affirmed. In Dunn, summary judgment affirmed because they said that it was not foreseeable that East Coast would act in a reckless manner. In Colina, summary judgment affirmed because Mr. Colina, much like here, but, being the person who was injured, then sued, but is also maybe negligent. In that case, in Colina, he violated the traffic laws. And in Pass versus Freeman, going to the question in that case, without any explanation, he said there's a break in the chain because of that half an hour difference between the moment of the accident and ultimately the second accident. In fact, 50 years ago, the Supreme Court in Cone versus Intercounty Telephone and Telegraph, which was cited by you, Judge Kahn, 15 years ago in a case that an opinion you wrote says that the liability of the wrongdoer is extended only to the reasonable and probable, not the merely possible results of a dereliction of duty. And that's important for all the parties in this case, because foreseeability and reasonably foreseeable, the linchpin of that is what's probable, not possible. And for that reason...
So, I'll extend the time here, but let me be clear on this because I started asking about the temporal aspect. Had this happened 10 minutes after this improbable act of the UPS truck sideswiping the other vehicle, would this have been an error to enter a summary judgment in this case?
I would say that if it happened in 10 minutes and with all the warnings and everything...
I left that out of my hypothetical.
Yes, you did leave
that out of my hypothetical.
Well, if you leave that out and there were no warnings, I would have to say that the question would be a lot closer for a jury to make a determination.
10 minutes after the sideswiping and the ASO guy was already out there with his blue lights, summary judgment would have been appropriate.
I think summary judgment would have been appropriate in that case because it was possible that it could happen, but not probable. But in this case, going back to Justice Kogan, it's the narrow facts on each of these cases we've got to look to. Here, if I might just say, reckless, careless driving, gross negligence, together, Justices, with the timing, the mile and a half, the 1 hour and 11 minutes, the 5 different indices, the black box, which shows no evasive action. So Mr. Cooke's unanticipated and not foreseeable, reckless, gross negligence in a highly unusual and bizarre freakish set of circumstances, we believe, have broken the chain of causation between the phantom vehicle and its actions and Mr. Cooke's failure to take evasive actions. And for that reason, Nationwide Mutual Fire Insurance Company asserts that it was a question of law for Judge Monaco, and we ask you to affirm on behalf of Nationwide the lower court's summary judgment in its favor. Thank you.
Thank you, Mr.
Hey, please, Court. Melissa Bodnar here for UPS and Nelson Ramirez. Would like to point out a few of the salient facts that were not previously discussed. One is that the Cooke-Kindler event was another subsequent event, the only other subsequent event that happened. Traffic was slowed but not stopped. And despite the assertions to the contrary, Kindler's actions were not sudden. Cooke had a duty to maintain a safe distance. He had a duty to decelerate upon approaching an incline. Kindler's lights were on.
I assume there are cases where the intervening cause, reported cases, where the intervening cause is the negligence of the plaintiff.
Yes, sir.
What are those cases?
In those cases where they have examined whether or not the person who was negligent was the person injured, you also have, I believe, additional factors. For instance, if you look at the Quokka case, Quokka versus Campbell in the 3rd District, there was the children next door put a tire swing on a rope. They said that this was not appropriate behavior. Children were involved. It was almost immediate. There was no warning. The defendant had not put that in place. And in that case, they found no liability against the property owner. Also in Deese, it's not appropriate to allow a child to exit a vehicle immediately next to the interstate and to cross the interstate. That would be negligence on behalf of that child. But again, it involves a child. And in many of the cases, they look at, from a public policy standpoint, children in different light. They also, in many of the cases, when they talk about you had no option but to render the aid, for instance, like in the rescuer case. I mean, it wasn't appropriate for him to stop.
So there really aren't a lot of cases where the intervening cause is the negligence of the ultimate plaintiff.
I have to say that in each and every one of these cases, the facts are always unique. And in this case presents, as our esteemed colleague, Mr. Avery has pointed out, this is a perfect storm. But really, the point of the law to impose liability is to look at the public policy for doing so. And the reason is to prohibit the circumstances from arising again. And we would submit in this particular case that there would be, under no circumstances could we recreate this particular perfect storm. Again, there are other factors that are significant. One is that Corporal Clark, who states most aptly and succinctly the juxt of the issue, that the normal prudent person wouldn't run into the back of a vehicle going that slow. When compared to the other drivers that morning, Mr. Cooke he's the only person who struck someone from behind.
I suspect Mr. Avery would stipulate to that. And I really don't see where it gets us, because that's contributory negligence.
Again, it's the issue of foreseeability has two aspects. One, it is appropriate to look at the geographic and temporal locations. When you look at the cases with respect to the temporal location, excuse me, Your Honor, my time has expired. Would you mind?
I will give you 1 minute.
Thank you, Your Honor.
Ask a question.
Thank you. With respect to the geographic and temporal aspects of it, they are fundamentally related and appear to be inversely related. When the geographic location of the negligence is static, in the sense of, like in the St. Fort case in the Stahl case with the tree roots and the bicycle path, or when you're looking at the case where it's an on-ramp and the location is static, timing isn't so much of a factor. But when the location of the negligence or the negligent act is not static, then you have to look at the timing. And in that circumstance alone, regardless of Mr. Cooke's actions, it doesn't meet the definition of the case's foreseeability. In addition to that, the cases do say when you are dealing with foreseeability, there's almost like an exception. It's almost like, and if it was foreseeable, if the behavior was so bizarre, highly unusual, or extraordinary, then you wouldn't hold them responsible for that. So that's the other aspect of it. And the way that we were looking at it is that his behavior, regardless of the foreseeability, even if you don't get to the point of saying, all right, we don't agree that this was something that was unforeseeable, it's foreseeable, even if it's a mile and a half and an hour and something later, the fact of the matter is this behavior is so bizarre, unusual, and unexplained and extraordinary that it would act as a complete bar to his recovery. The facts alone, specifically that Mr. Cooke traveled at 70 miles an hour in excess of,
I think you have.
I'm sorry, excuse me. Thank you, Your Honor. We'd ask that you affirm the decision.
Judge Collin, I think the court appreciates that the reason that we don't see appellate decisions that address an efficient intervening cause of contributory negligence is that contributory negligence or comparative negligence is not an efficient intervening cause. It may be an intervening cause, but it is not an efficient intervening cause. And an efficient intervening cause is that type of cause that a trial court must have to find that it is something that is so extraordinary and bizarre that the court is going to take the issue away from the finder of fact and determine as a matter of law and public policy that on those facts the original tortfeasor's acts are going to be absolved. I am going to disagree with my friend and colleague, Mr. Schwait, on possibility versus probability in terms of foreseeability. Possibility and probabilities don't come into play in foreseeability. It is whether reasonable people can differ is the standard for the trial court and this judge. And this court in 1966 in the Waters v. ITT Rayonier decision addressed some circumstances where a truck driver's going down Interstate 95, a landowner has a controlled burn, there's fog and smoke on the roadway, the truck driver hits a car from behind and is fired. as a result of that chargeable accident. That truck driver lost his job and made a claim against the landowner for his lost wages. And the issue in that case was whether that was a foreseeable event, a foreseeable harm, and whether there was a present and an efficient interceding cause. The court said in Waters, the trial court erred in concluding as a matter of law that Waters' injuries were not reasonably foreseeable by Rayonier. Although Rayonier may not have been able to foresee the exact manner in which Waters' wage loss would occur, a jury of reasonable persons might infer from the evidence that Rayonier could foresee the possibility of some injury, even the possibility of loss of wages in particular. So it is a circumstance, Your Honor, where if possibility is an issue, the Rayonier court addresses it and says if it's foreseeable, if it's possible, then the original tortfeasors must be held, well, not must be held accountable, but this issue must go to the jury on the issue of intervening cause. The defendants in this matter are in a position where they cannot prevail, I think, unless they can characterize what happened in Mr. Cooke's crash, the second crash, as reckless or grossly negligent. I would submit to the court that this is one of those things, foreseeability, that we know it when we see it. There's nothing in the record from which somebody can say that his actions were reckless. Negligent? Yes, that's going to be an issue in this case. And most certainly one could make the argument that Mr. Cooke was negligent. Nationwide says that the Deese case is distinguishable because the Hunt Club had knowledge of what was going to occur. We disagree. In the Deese case, the Hunt Club argued that a child leaving his father's side and running across the roadway was that type of extraordinary and bizarre event that was not foreseeable, and thus that was an efficient intervening cause. And the appellate court disagreed. They did not have knowledge of what was to occur, but the court agreed that it was reasonably foreseeable that such an event could occur. The negligence of Mr. Cooke does not, and I wish to stress this, does not make what happened in the second crash an efficient intervening cause. Negligence in and of itself has never been found sufficient to find an efficient intervening cause. Simply put, it was reasonably foreseeable by these defendants that subsequent crashes would occur. As a result, the lower court usurped the jury's function as a finder of fact in determining whether the second event was foreseeable, took that away from the jury, and entered summary judgment. That order was an error and should be reversed by this court. Thank you.